Hi guys, Rajiv here for immigration.com, the law offices of Rajiv S. Khanna PC. November 21st, 2013 conference call for the community. Let's start right away. I'm a minute late today. I apologize for the delay. It took me a little time to set things up. I'm on a different system today. Okay, there's a bunch of you guys on the phone, and what we'll do is we'll go on to the questions that have been posted. After that, we'll take on follow-up questions on the questions that have been posted, then any new questions that our visitors might have. Okay, let me get started. First question was from Nas8, who wants to know how to track a perm application. So the way it works is if the perm application was submitted online, you can at least know whether it is under review, whether an email has been sent to check whether the employer is genuine, or whether it's under audit, whether it's been denied. So online, most lawyers I know, I don't know a single lawyer who submits their applications by mail. Very rare circumstances we use mail. But if it's online, your lawyers can give you a screenshot. Okay? Vishal Pratap. Vishal has a situation where he changed from L1 to H1B with a change of status effective October 2013. So the question is it illegal to work with company A on L1B after October 1st? The answer is yes. Because beginning October 1st, you have changed status to H1B. And there is no gray area here. This is quite clear. Okay. Two, if I didn't join from October 1st on H1B, does that create an issue in green card approval in the future? Well, that's a difficult question to answer, but there are many ways around that problem. So typically, for green cards, this is not going to be an issue. Okay. Look up something called Section 245K as in kite. That might give you some idea of how well protected you are. You can just go outside USA and come back before filing I-485, and that washes away all problems of unauthorized work, etc. Okay. 3, employer is not giving the approval notice. This is also complicated. This sounds very unreasonable. Is the employer required to give you the 797, the approval notice? Probably not. Are they required to give you the I-94? Yes, they are. And I would go as far as to say that if they don't, I would file a complaint against them with ICE, with USCIS, and even with the local police, because it's your property. Your third question is, employer has put, actually it's the fourth question, you have number 2 twice. So fourth question is, my employer has put in a liquidated damages clause of $25,000. Well, you know what? Liquidated damages clauses in H-1B related contracts are a very dangerous area of the law. I have a multiple page article on this. So if you go to our website and look at the top tab under About Us, there is a tab about me, and there is articles written about us, articles written by Rajiv, sorry. I have an article that was published, I think, last year. It's a multiple page article where I have analyzed this issue in great detail. And you can share it with the lawyers who, if there is ever a contract-related dispute and litigation, you must share that article, because lawyers who practice litigation and contract law may not know anything about immigration. So there is a specific sub-area within immigration that impacts what the employer can put and what they cannot put in an H-1B contract. Okay, because we have done everything, we do everything, litigation as well as, everything related to immigration. We realize and we know several areas of the law. So, I found this to be a very problematic area, not only for small companies, but some of the largest companies in this country. I looked at contracts and found these provisions, and then I had to make them aware, this is not going to work for you. Immigration law has certain unique twists on liquidated damages and what can be put in, what cannot be put in. So I personally think they'll have a problem keeping you for 2 years. Okay, next question is P. Sandal. Vishal, by the way, I must add, you have to have the contract reviewed by a local lawyer. and take my article, a copy of my article with it, so that they can review it and figure out how they can fight this case if it ever comes to that. So, green card for parents. There are actually two questions today. I just read them a few minutes ago. Two questions about green cards for parents, and there are some similar issues here. Here is how it works. The time for processing an application, whether through consulate or 485, is not that much different, or at least in most cases it is not. So the time frame is the same, few months to a year, year and a half at the most, for both types of applications. But what is more complicated is, excuse me, I better switch this off. Okay, what is more complicated is if a parent enters the United States on a tourist visa and they have a preconceived intention of converting to green card, that entry can be considered to be fraudulent. It's a very, very important point to note, and I know that people have gotten into trouble with this. So let's say your parents enter USA on a tourist visa and they're carrying their birth certificates and their marriage certificate. That's a dead giveaway that they want to convert to a green card, and that can be problematic. Okay. If, however, they are here for a few weeks, few months, and decide after entering, 3-4 months down the line, they decide to change to green card, that is okay. There's actually something called a 30-60 day rule, which basically says if somebody enters on, for example, a non-immigrant visa like a tourist visa or a student visa, and within 30 days they try to change status to a long-term visa or a work visa or a green card, then their entry is deemed to be fraudulent. If they do it within 60 days, after 30 but within 60, then it's a rebuttable presumption, which means we still are looking at it suspiciously, but you can convince us why your entry was not fraudulent. But if you change or try to change after 60 days of your entry, we will accept that as okay. Okay, so keep these principles in mind. Okay, then this particular lady or gentleman had a question that can I-130 be processed when parents are in India? Yes. And thereupon, adjustment of status can be done when parents are in USA? Yes. But a couple of issues here. First issue that I already talked about, if they try to enter on a tourist visa and they have a preconceived intention, you got to be careful with that point. And second is their entry on a tourist visa could be denied. Sorry, I lost the track of my points there for a minute. So their entry on tourist visa can be denied. They show up at the airport and somebody at the CBP, when they look up their paperwork, or if they are asked, and it turns out that they have an I-130 approved or pending, the CBP can say, look, you cannot enter on a tourist visa because you have a green card going on. You have to return to India. Now, I'll give you this, that to treat parents of a US citizens so shabbily is definitely very bad policy and very bad manners. But the law is the law, and the folks of the CBP have a lot of discretion in this matter. So they could very well turn your parents away at the airport if there's a green card pending. 485 filing risk for current H4 dependent who had a prior H1 but partially employed. Sunny_India. Sunny says this: my wife came on H4, then converted to H1 but did not work. In between, she worked for a couple of months, but there is a period where she did not work. But in 2012, we went to India, got a visa, and came back. My attorneys are saying, when they review the G325, that there could be a denial of the green card. I disagree. I disagree. Your attorneys either don't know immigration law, they may not be immigration lawyers, or they have information that I don't have. Okay. Under Immigration and Nationality Act, Section 245K as in kite, as long as you don't have unlawful presence and you just have out of status issues, those are all resolved by leaving USA and coming in with a new visa and then applying for 485. So 245K completely protects you as far as I can see. Chanda says, and this is the one I was talking about, filing I-130 petition for mother from USA. Can she travel after filing I-130? And Chandaji, the problem is, if she tries to travel, they can give her trouble at the airport. Okay. Can she travel outside USA after filing I-130? Well, there is no problem with that. So let's take the situation. Mom comes in on a tourist visa. Then you apply for her I-130. Can she go out? Definitely. Definitely. But can she come back in again to file adjustment of status or 485? No. That could be problematic like I discussed earlier. She can. She can. I'm sorry that I couldn't get to this question by November 17th. I know that she's already flown. So let's just look at the question real quickly one more time. In the I-30 form 14, question number 14, I can't deal with specific questions. But if you tell the truth, you're okay. And the truth as it exists on the date of the filing. Okay? So truth as it exists on the date of the filing, if given to the government, that's good enough. Yeah, filing 485 is going to be problematic for you. You might want to convert your I-130 to consular processing. Okay, and you can do that by filing. If the I-130 is still pending, contact USCIS through the customer service. It's still pending. So contact them and say you want to convert it, and would they allow you to amend it? They might. And convert it to consular processing, let mom apply from her home country, and I'm assuming that's India. Okay. Next question, GK001, question on H4 extension. Wife and children have H1, H4 visa stamp till Feb 2015 with the previous employer. Joined the new employer in May 2013, got the new H1 only for 1 year till May 2014. This new employer did not file H4 along with my H1. See, my concern here is because there is an intervening H4 which is only good till 2014, I think before May 2014, you'll have to apply for their H4 extension again. Before May 2014, apply for their H4 extension again. Otherwise, they are good. Nandini wants to know H4 to H1B change of status on maternity leave. Working with a Desi consulting company A on EVC model retail client in Illinois. Having a baby, congratulations. Due date November 28th. Going on family maternity leave for 3 months from December 1st onwards. After maternity leave, I'm planning to visit India for 2 months. Going for H4 visa stamping, then coming back. Can H4, H1 change of status be filed immediately? See, it's the same issue. Remember the 30-60 day rule I've talked about in the beginning of this conversation today. The idea here is that the government can take the position people should not be filing for change of status from H4 to H1. Although I don't think it quite applies, but why take a chance? Might as well wait 60 days and then apply for H4 to H1. And definitely it can be done. And you can do it with a new employer, and you don't need pay stubs because you were on leave with the old employer. Okay, in any case, you are applying from H4 to H1B. Yeah, I think 60-day wait may be a good idea. or maybe not. Who knows? My own feeling is to always be as cautious as possible where the law is gray. And if we have to, we can be very aggressive. But in most cases, if there is a choice, let's be cautious. Sonia Tandon, H1B stamping without pay stubs. Working on L1B with company X. Y got approved for H1B, continued working. Okay, change of status was also approved. So that's unauthorized employment. After, I don't know if your H1B was effective August 2013 or October 2013. But once the change of status kicks in, you no longer have an L1B. Now you have an offer from company Z. They say they can transfer your H1B as a quota exempt. They are right, even though you don't have pay stubs. See, you are out of status, but that doesn't mean that you're subject to the quota. So you should be, Sonia ji, you should be able to get your H1B transferred over, but I think you'll have to go to India. And if you don't have the pay stubs, you don't have the pay stubs. There's nothing wrong with that. Company X has generated my salary for October and November on L1B. See, you have worked without authorization after the H1B approval because you couldn't be working on L1. And you do have to surrender all I-94s at the port of exit, even if you didn't join the company Y. So it appears to me that you should be able to get H1 without the quota issue, no problem. You should be able to go outside USA surrendering both I-94s, and you should be able to get an H1 visa stamping because, and be truthful about it. Don't conceal any facts from the consulate, whatever they ask you. You have worked without authorization on the L1B, but it is what it is. Okay, so that is not a ground for denial of a new H1B, which you'll be getting through company Z. Good luck. Next question, Jans J. My H1B, wife's H4 valid till 30th March, and this is the visa, 30th March of 2014. Employer has filed H1, H4 extension on 12th November. Wife had to travel. Is her H4 extension null and void? No, it is not abandoned. See, that is the difference between an extension and a change of status. So if somebody who has filed for an extension travels, the extension is not abandoned. Not abandoned, not in this case. Okay. So let her come back on H4 visa. She can re-enter any time before 30th March 2014. I don't see any problem with that. Sanju, Mountain Hope, wants to know, I'm completing my third year bachelor's on H4. I want to change to F1 since I'm aging out. If I apply for an F1 visa and get approved, do I need to apply for another F1 visa if I want to study at master's? Wait. There's a distinction between change of status and visa. I think what you're asking me is a change of status because Form I-539 is for change of status. And normally if you get change of status and you go on to the next higher degree, you should not have to do any major formalities for that. You have to go through the school, but it does not require a whole lot of additional filing with USCIS. Okay. I cannot answer specific questions on how to fill out forms, but the rule of thumb is very simple. Not everybody has an A number and not everybody has a social security number. If you have it, you supply it. If you don't have it, you don't supply it. Okay, next question is a little bit more complicated. Employer A's L1B I-94 expired on 20th August. This is PB4. I-94 expired 20th August. They filed an extension. And I'm assuming they filed it in a timely manner. H1B approved with change of status from 1st October 2013. Employer B wants you to resign. The H-1B employer wants you to resign and start on 1st December. There's an overlap of 2 months pay on L1. I would not worry. See, this is a different situation. Here, you did not find out about the change of status until December, even though it was effective 1st October. Okay. I'm assuming that they received the approval notice late. If they received the approval notice late, this is one of those gray areas where USCIS cannot raise objections if you continued working on L1 because they issued the notice late. Okay. So, and you can tell the employer you are joining H1B and you're not going to continue on the L1B, and that should take care of it. Is 30-60 day rule can be used to do AOS? 30-60 day rule has no application in your case. There's no grace period here, but you are protected if the notice was received late. Do I stay back with L1B employer or go with H1B? You can go with H1B, or you can do a change of status back to L1B, or go outside, get L1 stamping and come back. Man Kumar, change of status from B to H1B. I have discussed that in great detail, and it's almost never a good idea. And when you apply for a tourist visa, when you have an H1B stamping, consulates can cancel the existing H1 visa. Technically, before they take the new application, they're supposed to cancel all existing applications. I'm sorry, all existing stamps on the passport. So when you apply for a tourist visa, they should cancel the H1B. Sometimes they don't do it, but it's definitely within their rights, and in fact, it is the proper procedure for them to cross out all existing visas. Traveling while H1B amendment and extension pending, I see no problem with this. As I said, an amendment, an extension, they are the same idea. If there is no change of status involved, traveling is usually no problem. Okay, so if you have an H1B amendment going on, an extension going on, and you have a valid visa, you can travel and come back. Raj Kum 83, H1B visa transfer while in India without traveling to USA. So he's gotten approval through a company. He's got the H1 visa stamping. Question is, if I change over to a new employer without entering USA, do I need to go for restamping? And the answer is yes. Consulates have told us that we want you to come back and apply for a new stamp in situations like this. Is there a chance of getting an RFE? Consulates can question you very closely, but they always question all H1 applicants quite closely. But the fact that you have not entered USA and are going over to a new company should not be an additional problem. I don't see. Kumar, fun dude, moving from H1 to EAD. So he's got an H1B, he's been working on an H1B, but he's also entitled to an EAD, and he had an EAD, I guess based upon adjustment of status, pending 485. So his question is, I want to stop renewing my H1s. I don't recommend that. I think you should keep renewing them if it's possible. I came to know that we can only apply for EAD extension within 120 days. That is true. And while the extension is pending, if the EAD expires, I can't continue to work. That is true. So what happens if I don't get my EAD renewal in time? You go off the payroll. Is there a process where we can get emergency approval? There's supposed to be, but not all local offices have the machines that can do the EAD production. And also, USCIS is very inconsistent on expedited EADs. Impact of I-140 withdrawal after 6 years of H-1B. So Vinay was working for employer A, got the I-140 approval. transferred to employer B in September 2013, and got a 3-year H1 extension based upon the approved 40. Now the old employer has withdrawn the I-140. So what happens? After September 2014, end of my 6 years, will USCIS take back the time they gave? No, no, no. They will not take back what they have already given you. I've reviewed these regulations. Even though they are gray, as a practical matter, USCIS never takes back the time that's given. There's no USCIS article that I know of on this issue, but we know this from practice, also from knowing the law in general. I think what you should do is start another green card process with employer B right away. You are fine till 2016. Whatever they have given you, they're not going to take that away. Naveen Chikoti is planning to travel out of the country when he's in between jobs. So his question is about AC-21. Working for employer A, he's got a job offer from employer B, wants to travel on his advanced parole. Question is, I don't have a job in hand. I have a job offer. What is the best way to go with this if I travel outside? Well, I think company B should do the AC-21. And you don't have to start working with them. Just carry a copy of the AC-21. At the port of entry, if they ask you, who are you working for, company A or company B? The answer is very simple. I am going to be working for company B. Okay. If I start working for company B along with company A prior to leaving, will it help my situation? I don't think you have to do that. Just get the AC-21 filed. You should be okay. Now, this question is too complicated for me to go over. Guys, don't give me facts that are so long that it takes me half an hour just to understand what you are saying. I'll tell you the general principles. See how they apply to you. AKS 341. Need to reclaim period counted in H1B time while F1 OPT was approved. Okay. First of all, you can definitely take back any time you were outside USA while you were on H1B. So if you were on H1B and you were outside USA for 3 days, you can recapture that. Okay. Anytime you're outside USA. Another interesting thing about H1B, a lot of people don't know this, but just keep this in mind also. If any 12-month period, during any 12-month period, you are outside USA for more than 6 months while you are on H1, you can get the entire year back. You can recapture the entire year. Okay. What if you are in the United States and you are, let's say, either not in a job for a legal reason? For example, you're transferring over to a new employer. Can you recapture any of that time? Very unusual. Very unlikely. Time recapturing while you are within the United States is going to be very, very difficult. Okay, so I'm not sure what your facts are. Too complicated for me to parse through with the amount of time I have on this. If you're on the phone call, I'll be happy to talk with you and try to answer your questions generically. Mumi85 is a DV lottery winner. Nothing I can do for you, sir or ma'am. I don't know anything about DV lotteries. And the last question, posted question, is about change of status to H1B. Okay, so they have a perm under audit. The priority date is January 15th. Exhausted 6 years, applied for change of status to B1, B2, got it, and good till March 2014. 1 year of labor pending completes in January of 2014. Can I go for 1 year H1B from Jan 15th only? Yes. Yes. What are the chances of going from B1, B2 to H1B? I think they're pretty good, especially if in the B1, B2 you made it clear, and I'm sure you did, that you had a green card process going as well. So I don't see why it should be a problem going back from B1B to H1B. In case my change of status gets denied, will I have to leave the country immediately? Can I stay till March? You can stay till March unless USCIS says you cannot. Will this denial impact my future US visa? It shouldn't. It shouldn't. Okay. So I've answered all the questions that were posted. What I want you to do is, if you have any follow-up questions on what has been posted, please press, let me remember, I think it's *5. Press *5 on your phone. Yes, it is *5. 1, 2, 3, 4, 5, 6, 7, 8. 8 people have raised their hands. I'm going to go over these 8 people in the order in which they logged in. Okay, so the first person who raised their hand is New Jersey, area code 201823. Go ahead, please.
Hi, Rajiv.
Hello.
Can you hear me?
I can hear you. Go ahead, sir.
Yes, sir. I heard your response. I just want to reconfirm that.
Give me 1
traveling is not a
second.
problem.
Give me 1 second. Which question number are you?
It's question number 10.
10. Give me a second. Let me get to it so I know what we are talking about. Jans, J?
Yeah, Jan is here. Yeah.
Okay, traveling while H4 extension is in progress. Wife is here. Extension has been applied for. Her visa is still good. Can she travel during the extension? The answer is absolutely no problem.
Yeah, so in this case, the applied H4 extension should go through. That should not be a problem.
Absolutely. Remember, abandonment only occurs when there's a change of status requested. If she was on F2 and converted from F2 to H4, that is pending, then she can't travel. If she travels, she'll have to wait until H4 is approved, then come back on a visa.
Okay, got it, sir. Thank you.
You're welcome. Good luck.
Thanks.
Lexington, Kentucky.
Hi, Rajiv Ji. This is Vinay, and my question number is 1717.
1 second, Vinay.
Yeah.
One moment. Let me get to it. Okay, I have it. Impact of I-140 withdrawal. I don't see you have any problem. You'll be fine.
Yeah, in fact, I have looked at forums, and I have got a feedback from some of the attorneys regarding this, and I was very comfortable with this, and then transferred to a full-time employer here. So I just had, my first question is, just in case if my previous employer wants to reinstate my 140, will he have to apply a new firm, or will he be able to use the existing firm with which I got my first one?
That's a very interesting question. There is no law on this issue. I'm quite sure they should be able to use the same firm.
But this firm was, I think, it was way back in 2010.
So what?
So does that have any expiration date?
No, PERM does have an expiration date. PERM you have to file an I-140 within 180 days of the PERM approval. Okay, but
Okay.
once an I-140 has been filed within those 180 days, any subsequent I-140 for various technical reasons can be filed way beyond 180 days. So it'll be interesting to see what happens. I think they can use the same PERM. Yes.
Okay, so in your practice, I was just wondering if you came across these scenarios.
Not exactly the same scenario. Not exactly the same scenario. But we do I-140 refilings all the time. And this is written law. There is written law. There is a memo from USCIS that very specifically says, look, the first I-140, you've got to file within 180 days of the PERM approval. After that, if you want to file a subsequent I-140, for example, let's say there is an amendment necessary. There's an employer takeover. Or let's say, for any number of technical reasons, it got denied, the first one got denied, and you're filing the second one with new tax returns or whatever, You can file it way beyond
Can
1 year.
this be?
There is no limit on time.
I'm sorry to interrupt, but can this be? Can the employer say, okay, I have accidentally withdrawn my first 140, and this is the reason
Well,
why I'm doing it for the
first
second
of
time?
all, first
Can
of
you do
all,
something like
first of all, employers have to. I don't want anybody to lie to the government ever. It's got to be truthful, whatever the truth is. Okay, so employer can only tell the truth and nothing else. Let's agree on that, Vinay. That's number one. Number two, the I-140 approval. Remember one thing. This is a very interesting point of law. There is a law on the books, and government has followed it repeatedly, that through the entire period of green card pendency, until your green card is actually obtained, your job must not cease to exist. And I'll give you an example. This is an example from a case, from a decided case. There was a hotel, a restaurant, which was taken over by new management. New management closed the restaurant for 6 months for renovations, fired everyone, then rehired everyone after 6 months. Government said all pending green cards are gone because during those 6 months the jobs were extinguished. As long as the job was not extinguished by the old employer and they revoked your green card because you left them or whatever their reason is, as long as the job was there and somebody else was doing it, or they had kept it pending or distributed the job amongst various people, as long as there's a continuity of job, I view this as a case in which I-140 can be refiled.
Okay. All right.
Okay?
Okay, all right. Thanks, Ranjit. And one more thing, just in case if my current employer says, okay, my 6-year period is ending this September, and you'll be out of status, and you'll have to wait outside the country till you're 140. In fact, I just started my green card process with the current employer. So, can I go back? Just in case if these guys tell me to go back to India and then come back after the 140 is approved, can I do that?
You can come back whenever the next H-1B is approved, and that can be either based upon the pendency of this PERM for 1 year or I-140 approval. Definitely, no problem.
Okay. And I'll be cap exempt, right?
You will be cap exempt. You will be cap exempt. You become cap becomes an issue only after you've been physically outside USA for 1 year.
Oh, okay.
All right.
All right. Okay. Thanks, TJ.
You're welcome. Good luck.
Thank you. Okay. Thanks.
Okay. Seattle, Washington. Go ahead, please. Seattle, Washington.
Sorry, actually, I think I was playing something and
Okay, no problem. No problem. Are you a new question?
yeah, actually, first time I'm joining the call, I was not sure. I heard some star 5, so
Okay. No. I do a star 5 for those people who have a follow-up question. Stay on the line. If you have a new question, I'll take all the new questions at the end of this, okay?
Yeah, sure. Yeah, mine is a new question, so
Yeah.
I will wait.
Yeah,
Thank you.
please wait. Thank you. Okay. Next one is California. Campbell, California.
Hello, Rajiv. This is AKS 341. Can you hear me?
Yes. Question number?
Question number. So this is the question that you answered. Okay, I'm forgetting the question number. Let me.
No, don't worry about it. I'll find it. I'll find it while we are talking. Remind me what the question is.
So the question was it was titled "Reclaiming the Time on H1."
Oh yeah, you are the guy with that 20,000 dates. Okay. Yeah. Tell me.
Yeah.
Tell me frame your question generically so I can answer it generically.
Okay, so in 2005 to 6, I was working on OPT. I had an approved OPT after completing my master's, and after about 6 months, while I was working on OPT, optional practical training on F1 visa, my employer got H1 approved, that H1 state started in the middle of that OPT. So there was an overlap of 6 months.
Let me ask you a quick question. Hang on. Was there a change of
Yes.
status given? Did you get a change of status?
It was a change of status. Yeah, I was
So-
in the US. I did not travel outside.
That doesn't matter.
And right now,
Hang on.
sorry.
The moment you get your change of status approved, you are no longer on F1.
Right.
You are on H1.
Okay, I understand that. At this point of time, I have 14 months of time remaining on H1.
Okay.
And I'm going to get terminated in about 3 weeks or so. So I'm not able to find another job because of the limited time on H1, and I don't have a green card filed by my current employer.
Okay.
So I'm trying to figure out if there is any way to add to my H1 time. And I was trying to figure out any possibilities of reclaiming a period when I was working on OPT, F1 OPT, but the lawyers filed a H1. And I had requested the lawyers, to the best of my memory, to not do an overlapping of OPT and H1, but they just filed it with a start date while the OPT was just 6 months complete.
I don't think
So-
that's going to help you. That there is no reclaiming of that period. But you should apply for a B1 B2 to at least remain in the US for a time. And we have some detailed blog entries on this issue. You can go to my blog. I may have a couple of videos on this too. Earlier today, there was a note from somebody here in our forums in one of the questions I dealt with. If you look at it, you'll see that guy actually applied for B1, B2 and got it. He's good till March 2014 or something like that. So B1, B2 is a good way to go. And you can tell USCIS, I'm looking for new jobs, and make it clear. And the only thing they want to know is that you're not going to misuse this B1, B2. So read up on it on our blogs. B1, B2 may be a better option for you while you're waiting.
But the challenge is the remaining 14 months only.
You can't extend
on
that.
H1B.
There is nothing you can do about
Okay.
that. The laws on that are
Okay.
quite clear. Change of status approved.
Right.
You are on H1B. F1 is out.
I see.
And even
I
if the
see.
lawyers
Okay.
made a mistake, even if the lawyers screwed up completely, you are stuck with your lawyers.
Okay. And how soon the next employer should file a green card so that they can extend my H1 if I get a job? New
The
job.
PERM application should be filed before the 6th year kicks in.
Before the 6th year kicks in.
Okay.
Okay.
And the
All right.
more of an incursion there is in the 6th year, that is the time you'll have to be outside USA or in another status. Let me give you an example. So instead of filing 12 months in the last 1 year, they file it in the last 10 months. That means you'll have to be outside USA for 2 months. So just kind of proportionalize that thing. So
I see. Okay.
if they file it in the 6th month, then you'll have to be outside USA. In the 6th month of the last year, you'll have to be outside USA for 6 months, unless something truly miraculous happens and your I-140 gets approved. But that's the rule of thumb you should follow. It should be filed
I see.
before 6th year starts, and the more incursion there is into 6th year, the more of the chances that much time you have to be outside US or in another status.
Okay. I would have to be out of state, out of the U.S. During that incursion period because
Correct.
of the possibility that the firm may not get approved by that time.
Well, PERM and
And the
I-140,
I-140
both of them have to be
PERM.
approved. Yes.
Right. Okay.
If they get approved within that time, then you're all set.
Okay. Because I would get the I-140 based on the I-140 approval, a 3-year extension. So the only thing is that I'll have to spend possibly, let's say 3 to 6 months outside of US.
Look, you have 14 months. Okay. There is a bright chance that your application for PERM can be filed in those 4 months.
in those 4 months, in those 2 months, right?
Oh,
More than
14.
a year.
I'm sorry. I was counting 16 months. If it's 14 months, no. 14 you will not be able to do. You might have to go out for a while unless the I-140 gets
Okay.
approved. But also remember this, that if you are outside USA, green card can still go on. The employer can actually send you work in your home country or wherever you are, and they can pay you on a
Okay.
W-2 or a 1099 as far as I know.
Okay.
So,
Okay.
so really,
So-
there is
so
no reason for there to be any substantial loss to you or to your employer.
I see. Okay.
Okay.
All right.
Good luck to you.
Okay. Thanks a lot, Rajiv.
You're welcome. Bye bye.
Bye.
Okay, I don't know how this is pronounced, Camarillo or Camarillo. California, must be Camarillo, right? Camarillo, California.
Yes. Yes, Rajiv. This is a new question.
Oh, new question. Wait, I'll get back to you.
Yes.
Okay, 4 more raised hands. Let's go to Tulsa, Oklahoma. Go ahead, please.
Hi, Rajiv. This is GK001.
Which question number are you, GK sir?
Number 7.
Number, where the heck am I? Okay, 1 second. Number 7. GK001, H4 extension. Oh yeah. 2014 your H1 was expiring, so I said file their H4 extension before May 2014. Okay, yeah, go ahead.
Actually, me and a couple other guys are on other bridge, so I couldn't hear what the answer is.
Oh, okay, I'll give you the answer. I'll give you the answer. Oh, so you went to the other bridge, the 9-5 bridge.
Yeah.
No, that's for
Yeah,
that's for
8-3-9-5.
that's for client calls.
Me and other few of them were there, and we.
Oh, no,
one
I'm
guy
sorry.
confirmed the number.
I'm sorry. This must be because we changed community call bridges to 9-4 and client calls to 9-5. Okay, now what I said was this. This is going to be recorded anyway. What I said was they are okay for now, but before May 2014, apply for their H4 extension.
Okay.
I think that's the safest thing to do.
Okay, because within 6 months before they start again H1 extension, because so at that time I can ask them to include and we can apply
Absolutely.
for H1.
Absolutely. See, what happened was there's an intervening period where you only had H1 for May 2014. It can be argued that the H4 and H4, instead of going all the way to Feb 2015, at that point it became constrained to May 2014. I know I'm being highly paranoid, but I would rather be paranoid than sorry later on. So just get the H4 extended before May 2014. File it before May 2014.
Okay.
All right?
Yeah, thank you very much.
You're welcome.
Because they are just say that it's not needed. You have a visa up to 2015 in the passport. You don't need and all the stuff. So that's what I got confused. So that's really.
No, I think it's better to be cautious. And I learn something new every day. Today I learned something. Honest to God, I've been doing it. I've been doing it for 30 years, and every day there's something new that comes up. So it's always good to double and triple check. In my view, it should be done before May 2014. That is the safest thing to do. You should be fine. And no problem with the green card process. You'll be fine.
Oh, great. Thank you very much. I appreciate it.
You're welcome. Okay, 3 more people with old questions, and then we'll start with the new ones. First, okay. I guess MO is Missouri, right? Chesterfield, Missouri?
Hello?
Yes, ma'am.
Hi. My number was number 11 about the H4 to F1.
1 second. Oh, you are aging out. Getting old, huh?
Yeah.
I'm sorry to hear that.
I was one of the people that was in $9-5 conference. I wanted to hear your question or your answer, and also.
Oh, okay.
ask you
I'll give you the answer, although it's been recorded already. I'll tell you what I said. Let's see. Completing my 3rd year bachelor's on H4. I want to change to F1 since I'm aging out. If I apply for an F1 visa and get approved, first of all, I said visa and status are two different things, ma'am. When you do a change of status, you don't get a visa, but basically you get an approval from USCIS that says you can continue to study here and stay here. You'll apply for a visa only if you travel outside USA.
Okay.
As long as you're within USA, all you need is status, not visa. So, first of all, once your F1 status gets approved using Form I-539, going from bachelor's to master's is not an elaborate documentation process. It can be all done internally within the school. So it's not going to be a problem. Don't worry about it. Okay? Now, you said A number, SSN, are they mandatory? Well, if you have them, you write them. If you don't have them, you don't write them.
Okay. So also, like when I write the F1 letter, should I mention that, I had an EAD before and I worked and all that stuff, since I'm mentioning the A number and the SSN and the 539?
You had an EAD? Oh, you had an EAD because you were... Wait a minute. That doesn't make any sense.
Yeah.
How did you get an EAD?
Yeah, because my father was on an H1 before then. He had an EAD, but that got denied because he got an RFE and the company replied really late. So that got denied, so he changed back to an H1, so now I'm an H4 again.
Okay, so basically what you're saying is, now that's new to me, I didn't understand that part. What you're saying is, what you're saying is your father was on H1, then he filed a green card, got all the way to the 485 stage, got an EAD, and you got an EAD through him as well, right?
Yes, that's right.
Okay. Well, Form I-539 does ask you all those questions. And I think you will of course have to disclose all of that.
Okay. So, would that cause any problems when I'm applying? That change?
Sanju, it can cause problems. It depends upon how tough the government officer who's viewing the application wants to be.
Okay.
I have seen hundreds of cases like this get approved without any problem. Okay.
Okay.
But I have also seen a few cases where they start questioning you very closely. If you look at the F1 visa or F1 status requirements, one of the requirements is that you must have a permanent residence in your home country. Well, obviously your whole family is here. There is no permanent residence.
Yes.
Okay. So we argue in cases like that you have to, Mr. USCIS, you have to apply the law to the circumstances, not try to apply the same law without understanding the change in circumstances. The spirit of the law is that the person who is applying is not going to break the law and stay here illegally. Look at the family, look at her own history. She is going to school, she is maintaining a good average, if you have a good GPA. Agar aap meri tarah nalayak hain, if you don't get good grades in school, I never did, then, it's a different argument. But the argument here is, look at my history, look at my background, and approve my case. I think you'll be okay. That's my guess, Sanju.
Okay, thank you very much.
You're welcome. And if you get an RFE on your 539, give me a call, okay?
Yes, I will. Thank you.
All right, good luck. Okay, Union City, New Jersey. Union City.
This is Manish.
Manishji, what question number are you?
Question number 13.
Lucky 13. 1 second. Okay, I got you.
So Rajiv, first of all, thank you very much. I did a consultation with you before filing H1B. For me and my wife, and both of them got approved.
Okay, very good. I just want to make sure कि आपने मेरे साथ झगड़ा करने के लिए फोन तो नहीं किया ना?
Rajiv, now what I'm trying to do is I'm trying to get it stamped. So the first question is, can I use B1, B2 option? Because I already planned a trip when I was in the US, thinking that I'll be in the US on H1 in November. So I did plan a trip with few of my friends, and I'm currently in India without my H1B stamp.
Okay, I don't think you heard my answer. I've already answered this question, of course. Did you hear my answer or no?
I was actually I was actually logged into the other.
Oh, the 95 number. Okay, let me give you a quick rundown. You can listen in on the recording later also. It's not a good idea to apply for a tourist visa when you have an H1 approval. A couple of reasons. One, government is not likely to view this application. Again, government is full of surprises. I don't know what they are going to do. But just relying on common sense, they're not likely to view your tourist visa application with much favor because you have an H1 approval. Second is, remember that technically, every time you make a visa application, the consulate is supposed to cancel out all the existing visas on the passport first. So if they follow their procedure, they don't always do it, but if they follow their procedure, they will take your tourist visa application, cancel all existing visas, including the H1B, and then if they deny the tourist visa, now you have nothing.
Oh. Okay.
So my advice
Rajesh,
would be to be cautious. If you are prepared for that eventuality, then do it. Otherwise, don't. Okay.
No, I would not like to risk my H1B.
Yeah.
So the other question I had was the company which filed my H1B. It's a consulting firm with who filed my H1B with an in-house project. It's a 25 million turnover company. They have around. They are doing products. They are actually genuinely creating a product, but they do not even have a client because it's being developed. So
that's
do you
okay.
think that I should prepare for stamp?
That's okay. I mean, as long as the case is genuine, we have plenty of companies that do that. As long as the case is genuine, we have plenty of companies that are manufacturing their own products. Some of them have products in the market, some have new products that they are coming up with. As long as the case is genuine, I don't have a problem with it.
So the company is actually a consulting firm with 100 employees.
So what? I mean, if they are developing a product, they are developing a product. I mean, I don't have any problem with that. Okay, but if you are saying you want to change to this company and then go back for a visa stamping, um, their lawyers have to be very, very careful. Make sure that they indeed have in-house employment. Okay, they're not just making it up. As long as there is genuine employment, I think you should try it.
Okay.
But tourist visa is not a good idea in my opinion.
One last question, Rajivji. The H1B for my wife was approved before I left US, and it was filed with COS.
Okay.
But we left the US before October 1st, so the COS would be void for her, right?
The COS is gone. She'll have to apply for a visa. Yeah.
Okay.
Okay. Anything else?
And we will be cap exempt for next 6 years.
You'll be cap exempt for the next 6 years. Correct.
Thank you, Rajivji. Thank you very much.
You're welcome. Good luck. Okay. Last follow-up question. Then we'll start on the new questions. What is this? Algonquin, Illinois. Go ahead, please.
Yes. Hi, Rajivji. This is question number 21.
21.
I was also on the other line, but
Acha.
I was able to hear a little bit about this, the B1, B2 to H1B.
Okay. Give me 1 second. Give me 1 second. Audit in June 2013. Audit is pending. 6 years. Applied for change of status to B1. Oh, you got your approval till March 2014. You're on B1, B2. So in mid-Jan, you can get your H1B extension. What are the chances of approval for B2H? See, cases where you have made it clear to the government a green card is going on, no problem. You should be able to go from B to H1B. Can you hear me?
Yes.
Okay. Yeah, cases where it has been made clear in the B1, B2 application that you have a green card going on, converting back to H1B should not be a problem.
Okay.
And if it does get denied, I don't see how it can impact your green card or any other job applications. So I wouldn't worry about it. I think you're going to be fine.
So you're saying that if it gets denied, but still I'll be eligible till March, right? Because B1, B2 is approved.
They will, unless they decide to cancel that, for which I see no reason.
Okay.
If they deny the H1B, they should still let you stay till March. Yep.
Okay. The follow-up question was that in case of denial for H1B, and then once I complete my March time frame, I can still apply for a fresh visa later on if I go back, and then I can still apply. There is no impact on the future US visas, right?
No impact.
Any kind of visa denial.
No impact that I can see. No.
Okay. And Rajivji, for B1, B2 to H1B, should I go for a premium or a normal process? Because I already have a
personally, I don't see a difference in the amount of scrutiny they place on it. So I don't see why you shouldn't go for premium personally.
Okay. So there should not be, because I just want, because we still have 2 months, so I want to make sure that typically normal process it takes 8 to 10 weeks for approval, right?
No, it can be more than that.
Oh, it can be more than that.
Mm-hmm.
Okay. But premium should not be an issue. I just want to make sure,
No, I would go for premium. Why not? Okay. I have a quick question for you. How did you end up on 9.5? Where did you get the 9.5 information?
9.5.
You were on the other phone number, right?
Yeah.
And
but I don't know. I mean, I think that I was using the same number which is being mentioned in the website, and no one was able to hear you, and few folks were there. And
okay. Sumanji, tell Monica to check where on our website and other places the old number is still there, because we have a separate bridge now for conference calls for the community, which is 9.4. Some of the people were waiting at 9.5. Please make sure that gets corrected everywhere. Okay. All right, sir. Good luck to you.
Thank you, sir.
All right. Bye-bye. Okay, guys. Anybody who has any questions, new or old, go ahead and raise your hands. You do that by pressing *5 on your phone. *5. 5 raised hands. Okay, now remember 6, 7, 6, 7. Okay, back to 7, 8. Now is the time, guys. Whoever raises their hand now, I'll make sure I answer their questions, but then I'll stop the call after that. 8 questions, 8 new questions. Okay, I'm going to proceed in the order in which people logged in. Okay, whoever called in first, we'll start with them first. Bellevue, Washington. Go ahead, please. Bellevue, Washington. Area code 425443.
Oh, yeah. Hi, Rajiv sir. This is Komal from Benton, Seattle.
Ji.
I just came to USA on 2nd of this month, and I was on re-entry permit because of my dad's illness.
Okay.
And my re-entry permit expired on 14th of this month.
Okay.
But now again my dad's condition is not good, and I had to go back.
Okay.
So is it possible to get a re-entry permit second time without any problem?
A couple of quick questions from you. The answer is, first of all, yes. You can get re-entry permit if you have a reason for it. Are you married, Komalji?
Single.
Okay.
And I have a GC, green card holder.
Obviously, otherwise you wouldn't be looking at re-entry permit. So here's what you will do. You will apply for a re-entry permit and wait for the biometrics, do the biometrics, and then you can leave. And the re-entry permit can be sent to you either in India or to an address in USA. So to answer your question, can I get another extension based upon father's illness? And the answer is yes, you can.
Yeah, and how should I represent my case so that they won't deny?
I don't think anybody can guarantee approval, but personally, Komaji, I think you should get yourself a lawyer. I don't think it's something you should do yourself.
Oh, okay.
All
Thank
right.
you, sir.
Good luck.
Yeah. Thank you, sir. Thank you.
Okay. Seattle, Washington. Go ahead, please.
Hi. So I was asking about actually I was applying for H1 and last year, and at the time my wife was actually currently I'm on L1.
Okay.
So I also applied for my wife's H1, assuming that if I go on H1, she will have the option to work. But mine got rejected, and she got approval now. So she recently only she got approval, and now I am thinking what if basically she's not working. I mean, we applied through one small consultancy. My concern is, for example, because she's not working, how to maintain the H1 status.
You can't maintain. You cannot maintain H1 status without getting paid. And don't get into that. Some people have this scheme where they'll get a pay stub issued and a paycheck issued, then they cash it and give cash back to the consultant. That's illegal. That's criminal. Don't do that. Tell her to convert back to L2.
Yeah, that is correct. So my concern is how to convert it to L2 basically.
Okay. Does she have a visa? She must have an L2 visa stamp, right?
Yeah, she's having L2 visa stamp currently.
When was her H1B approved? October 1st onwards?
November 1st, this month only. The 1st of this month.
Okay.
November 1st.
So, in my view, the employer still has 60 days to place her on the payroll. So, if that means she's not out of status right now. So, if she were to travel outside USA and re-enter using her L2 visa stamp, she's back on L2.
Okay.
Make
so
sure
if she doesn't.
Make sure you get a new I-94 based upon the L2.
That's correct.
Okay.
Yeah. So my main concern is if the pay stubs are not running or something for the 60 days, it is fine. We can still maintain the status, and it is not a big concern.
The law says this: the employer has to place the employee on the payroll within 60 days or whenever they report for duty, whichever is earlier, if the employee is in the United States. If they are coming from India, that period is 30 days. If they're coming from outside US. Yeah, I know. So for 60 days, if she's not ready to report for duty, she is in status. She's not out of status, but she should get back onto L2 with a visa re-entry.
So, for example, if I apply for change of status at this point, I mean, for example, this week,
do
I need anything from the H1 employer?
No.
Her employer.
No, you do not, as long as you make it clear that you decided not to join the job and you want to go back to L2. And the Department of Labor regulations allow 60 days. So, yeah, but again, get yourself a lawyer. This could get a little tricky. But why do you want to get into all that? Why don't you just have her travel outside USA and come back using L2?
Sorry, what is that?
Just have her travel outside USA and come back using L2 visa.
But if they ask something if they are saying, okay, are you maintaining the H1? For example, if I go and visit Canada, which is near, does it going to work out?
Well, if you go by road and the trip is less than 30 days, they don't take your I-94. Okay, you have to specifically surrender it. Go to the border and tell them, I'm leaving Canada, but I want to come back on L2 visa. Here is my I-94. When I come back, I want a new I-94. Okay.
So you're saying if I go by car also, I can do that, you're saying?
You can try. You can call CBP ahead of time. They actually usually respond to phone calls. You can call CBP and ask them if this is possible. Otherwise, you have two choices. It is my belief, you can check with the travel agent. If you travel to Canada by air, you do surrender your I-94. And when you come back, you can get a new I-94. Okay?
Yeah, when I come back, I can explicitly ask, I want it on L2.
Right. And also remember, you asked me one question. how do I answer the question about H1? You tell the truth. Whatever the truth is, never, ever, ever, ever lie to the government. Just tell the truth.
I can say that like I was expecting that she might get a job, but she is not getting the job. That's why like I want to her back on L2. Is it a fair answer?
If this is true, then this is the correct answer. Yes.
Okay. Because I think when employer applied for H1, obviously we will put a fake thing, right? Saying that okay, she's having a job or something like that.
Well, they should never put that. You should never be a part of something like that because that's a criminal offense. They should never put a fake thing unless they have a project in hand. Nobody should apply for an H1. Nobody should be a part of that application.
Yeah. Generally, the way it works is they assume that okay, we are going to put her in some client location, and that's how we get the visa, assuming that everything is going to work.
No reputable employer, no law-abiding employer will ever do that.
Okay. And once she comes on to L2, what should happen to that H1 with the employer? So he is supposed to inform USCIS and cancel it or something?
That's not your problem. Don't worry about it.
Okay. Because like later, like 1 year or so, if she wants to go back on H1, is it still legal and all? Because
yeah, she'll be exempt. She'll be exempt from the H1 quota. No problem.
Okay. Yeah. Thanks a lot. So
you're welcome.
I finished my question.
Good luck. Okay, we have 6 more questions. Let's see. Campbell, California.
Rajivji, I spoke with you a few minutes back, but I wanted to clarify something. This is question number 19.
19.
Where I wanted to talk about, this is AKS 341.
Oh, yeah.
And the question was about reclaiming the period counted in H1B, and you answered part of my question.
Okay.
Sorry to answer again, but this is little tricky for me. So, while working for my current employer on H1B, I was outside of the US for 1 month in India, and you mentioned that anytime someone is outside of US on H1B, that time can be reclaimed from my H1 total time.
That time can be recaptured, yes.
So I was on vacation, right? So I can still reclaim.
It doesn't matter what the reason is. If you were on vacation or even if you were working for the employer while you were outside, as long as you are physically outside USA, you get the time back.
I see. Okay, so that is 1 month. So that makes it 14 to 15 months. And the other part of my question was, in 2008, I had lost my job, and the other employer, the next employer who filed for my H1 petition, that petition remained pending for 18 months. And I worked for that employer for 1 year while the H1B was pending in so-called security check, for which I had no information. And after having that H1 pending for a year, I left the US because it was just hanging in there. What would that time period get counted in? Is it counted as part of my H1 total time, even though it was a pending H1 and I never got the approval while I was working? I went back and came back on F1 visa 6 months later.
This time period, the earlier H1 that you had before you joined the new employer, when was that expiring?
Right.
When was that expiring?
So the earlier H1 expired in October 1, 2008. And I started working for the second employer in March of 2008 on the pending petition of that employer.
And when was that case approved, or was it denied eventually?
No, it was not denied. There was no RFE. There was no question. Just one letter that the H1 petition is pending in some administrative processing.
Then what happened to that case eventually?
And so here's the sequence of events.
No, don't give me the sequence. No, hang on. Stop. Don't give me the sequence of events.
Okay.
I only want to know the ultimate decision on that case. What happened?
That H1 was approved in 2009, August, when I was already in the US on F1 visa.
And effective from which date to which date?
effective from August of 2009, when it was approved, to March of 2011, the requested date in the petition.
Did you get a change of status?
I was already on my F1 visa and I was a student at that time, so I did not leave my MBA program. I continued to remain a student.
I think that period is not H1 period. I think that between 2008 to the point once the old H1 expired to the point you started the new F1, I don't think you had any H1 period during that time. Okay. Again, see, I'm sorry. I have my time is a little limited here. I can only go into this much detail because I have 7 other people waiting. But the bottom line is there may be some gray area there that you might be able to figure out. So work with your lawyers whenever you do the H1. Work with your lawyers. They might be able to massage something out of that time. Okay?
Okay.
Good luck.
That was helpful, sir. Thank you so much.
You're welcome. Bye-bye. Okay. Let's see. We've got 6 more questions. Princeton, New Jersey. Go ahead, please.
Yeah, hi. This is my question number 6.
Okay.
Okay, Rajiv. You told me thank you so much for that. My mother, I filed for her, and I got in the mail that, and I just filed on the Wednesday on the 13th, and I thought that if she files the 130, she would come back because she had a family emergency. And my question to you is that now that you said that, can she first of all, you said she cannot come back and file the 485, correct?
In my view, that's dangerous because if she comes back in with a preconceived intention of converting to 485, USCIS is not going to like it.
Right. And is there any explanation or form or any process that you could explain that it was an emergency or family emergency that she had to leave after filing 130?
The issue
is there a form?
There is no form, and the issue is not really why she had to leave. The issue is why is she re-entering using a tourist visa when she wants to convert to a green card. That's the issue.
Okay. All right. So, say, then we have to use consular processing. So, would she file from, she's with my sister, and if she had, my sister's in Dubai, so she just, got a job. So, thodi gadbad ho gayi thi udhar, she wasn't well. So, the whole thing is that now, if she has to do for consular processing, would she do it from New Delhi, India, or would she do it from an Indian embassy in Dubai?
Where is she living?
Abhi to she is in Dubai, but then if my residence is in India, New Delhi.
Okay. Well, here is how it works, Chandaji. What you can do is you can send an email to the Dubai consulate, U.S. consulate in Dubai, and see if they will accept her green card application. But New Delhi she can do, definitely, there's no question about that. But Dubai has the discretion of taking her application, and they probably will.
Right, and I think was other confusion is if it's possible she should file from then New Delhi, right? That would be easier.
So Dubai to Delhi flight is a short flight. I personally would do it from New Delhi.
Personally would, yeah, that's what in case, that mujhe I'm just having second thoughts, but my mother still wanted me to ask, is it possible that, have you ever heard somebody withdrawing 130?
You
just
can.
To say that our intentions are to remain on a tourist visa?
No, you can, but it's not a good idea. This is one of those bells that you can't unring. एक बार ये घंटी बज गई तो इसको वापस नहीं ले सकते हैं. So even if you withdraw, you have exhibited the intention, and that intention is attributable to her that she wants to live here permanently. तो इसमें कलाकारी मत करिए प्लीज. जो सीधा सीधा काम करिए, दैट इज बेटर. थोड़ी बहुत तकलीफ है इसके अंदर, बट इसके अगर आप प्रॉब्लम में फंस जाएंगे तो तकलीफ इज अ लॉट मोर. सो rather than getting into a much bigger trouble, it's better to take a little bit of pain in the beginning.
Okay, so now it's agar 135 ho gaya, so there's no way, like you said, ki wo re-entry karne denge, because...
Well, I won't say that. I won't say that. I will not say that. Because if they don't notice, or even after they notice, they can let her enter USA, The problem is filing the 485. 485 should not be filed with a preconceived B1, B2 entry. So issue is not only of entry, the issue is filing the 485 after entry.
Got it. Understood. I think that was very helpful. And again, that's really helpful. Thank you so much.
My pleasure.
Really appreciate it. Thank you.
Good luck to you.
Thanks. Bye.
Okay. We have 5 more questions. And let's go back to Camarillo, I guess. First of all, tell me, am I saying this right, Camarillo?
Hello?
Is it Camarillo or Camarillo?
Camarillo.
Camarillo, okay. Camarillo, California. Tell me, sir, what can I do for you?
Yeah. Good afternoon, Rajiv. So my question is, like, if the 485 has been filed without an amendment of I-140, like whatever reasons, maybe because so what are the complications, and if any, to avoid further down the line, and that if the AC-21 is not applicable?
Okay, I have no clue. This question has so many different facets. It is impossible for me to really have a good answer. First of all, if at the time of filing the 485, an I-140 should or must have been amended for whatever reason, then the government can throw out the whole application saying the application was filed incorrectly because the I-140 was filed without first amending, and the 485 that accompanies it is based upon a faulty I-140, so they can throw out the whole application.
No, if it was approved I-140, right?
Look, I'll give you an example. Let's say you have an approved I-140 through IBM. IBM gets bought over, or that part of IBM gets bought over by Sun Microsystems.
Okay.
Under the law, Sun Microsystems must file an I-140 amendment, depending upon some different circumstances. But let's say they are required to file amendment, and they don't. You file the I-140, IBM I-140, and you file 485. Government can throw out both applications.
Okay. No, but in case, Rajiv, like if the lawyer had said that based on the UCS direction, they did go through and they send all the documents. In that case, like what I'm saying is like they have done, and in that case, like if it is not any shortcoming on the applicant's part, so is there any further the road ahead if the complications, and is there any way to avoid those, and what were the possible ways to get?
There is no way I'm not going to be able to answer your question. It's too vague. I don't have enough facts. Okay, so you may want to do a one-on-one consultation and give me all the facts. Let me look at the paperwork. But generally speaking, an application with an I-140 amendment required can be thrown out in totality.
But there is no other way in case. So unless until you have a look, you cannot suggest ways.
I don't know what the case is. I have no idea.
Okay.
All right. Sorry.
Okay.
Bye-bye.
No problem. Thank you.
Okay. Let's see. Let's go on to we have 4 more questions left. Union City, New Jersey, go ahead, please. Union City, New Jersey, go ahead, please.
Hi Rajiv sir, this is Manish again.
हाँ जी Manish again, कैसे हो आप?
Sir, I'm good, thank you. I have 3 more questions rather. The first one being, can I transfer my approved lawyer before stamping?
No, which question number were you, Manish?
It was 13.
एक second. 13. हाँ B1 हाँ याद आ गया. अच्छा. So what was your question? Go ahead.
My question is, I have an approved H-1B, and can I transfer it before even getting it stamped?
The answer is yes. Next question.
And if USCIS denies or rejects my H-1B stamping, will I still be cap exempt? Will any other employer still can file my new H-1B for me?
USCIS does not stamp your passport. Consulate does. Is that what you're asking me? If the consulate declines your visa, are you still cap exempt? The answer is yes.
And the other new employer can file another H-1B application using my receipt number.
Definitely, unless in addition to declining your visa, consulate also revokes your H1. They send it for revocation, and the USCIS ultimately revokes it. Then I don't think you are cap exempt. I have to look at the law, but I think you will not be cap exempt then. But if they merely deny the visa, then any employer, without you being subject to the quota, can still transfer your application.
So in what cases do they revoke it? Only if they find something mischievous being done?
If they are not convinced that the H1 should have been approved.
Okay.
Okay?
And what can I do to get my H-1B copy from the consulting firm who's not ready to share it with me?
What can you do? What is the question?
To get my H-1B copy, the copy of my approval notice, I-797, from the consulting firm who filed my H-1B.
See, in order for you to be quota exempt, you don't really need a copy of the approval. We've done quota exempt H1s just using the receipt number.
Okay, but even though if I need my papers,
I don't think you can do much. You can file a Freedom of Information Act request with USCIS. There is a form for that. Do you remember the number of the form? File form? I think G638 or 639, something like that. Freedom of Information Act request might get you some of those documents. Okay. Listen, I've gotta go. Okay, I've spent a lot of time with you. Let me go on. It's not fair on the other people who are waiting. Okay, I gotta go.
Okay. Thank you.
You're welcome. Okay. Last three questions, guys. Let's go on to Cincinnati, Ohio. Go ahead, please.
Hi, Rajiv. Can you hear me?
I can hear you, but you speak up a little bit more. My ears are going. I'm old.
Okay. Actually, I was on the other line, 9-5. Right, question number 3.
Question number 3.
Although I didn't hear your answer, I'll hear in the recording. That's not a problem.
Okay.
Now the situation has changed a little. The thing is that now my employer has given me the petition and all, and another company has offered me a permanent job, and they're transferring my H1 here, without the pay slips being generated by the first employer because I never joined him. So what they're saying is, after we, file your H1, we get the receipt. Just join us with the receipt number. Now, what I feel is I should join only if my H1 is approved.
I agree with you. It's illegal for you to join them with just the receipt.
Okay.
Okay.
All right. And I just had one more question.
Go ahead.
In case I go back to India and I try and, go for stamping and I get rejected, I think you answered with the last caller also. I'll be cap exempt in case my petition is still valid, right?
That is correct. That is correct. That's the same situation. Exactly. Yes.
All right. Thank you.
You're welcome. Good luck. Okay, last 2 calls. Ramsey, New Jersey.
Good afternoon, Rajiv ji. Actually, I was on H1 for 5 years, and then I had to go to India on emergency basis, then came back on B2 visa. Now, my employer is asking me to join back to the job. So can I go to Canada and get a new H1B stamping and then enter back on H1?
Yes, you can. That is a much better way of doing it rather than trying to convert from B to H visa.
Okay, but do I need because I am on B2 visa now, my employer has to apply for a renewal of the H1 after I went out of the US. Right?
Okay, hang on one second. Is your H1 approval still valid?
No, it's expired by September.
Yeah, they have to apply for an extension.
Extension. So before they start applying for H1 extension, I should leave the country. I should stay in Canada for like 3-4 months.
No. When did you enter USA?
Second time I entered in October 1st.
No, right now you are entered in
my B2. Yeah.
Hang on. Take your. Let's just make sure we get it right. You entered USA the last time or most recently in October. Is that correct?
Yeah.
Okay. October, November. Which day of October? First October. So over 30 days. I would wait 60 days before starting the H1.
Okay.
Okay.
In US?
Yeah, in US. And you can stay in USA while the H1 is going on. Once it is approved,
okay,
you can go to Canada, get a visa stamping and come back.
Okay, so the application can be just a renewal of the H1, not a change of status from BT to H1.
Do not do change of status. That can be dangerous for you.
Okay, and I can very well be in US on B2 visa while they're applying for perm, they're applying for they're applying for a labor, and then when they're applying for the renewal of the H1.
You can stay. You can stay here till the H1 is approved. As long as your B1 B2 is still valid. As long as your I-94 under B1 B2 is still valid. When does that expire?
April 2014.
Yeah, so you are good till April. But by the way, these are just very general suggestions. Keep them in mind, but do check with the company lawyers what they suggest. And if they are saying something other than what I'm saying, you may want to do a second opinion, or you may want to come back on the conference call and talk to me about it.
Sure, Rajivji. I was thinking, go to Canada and then have this employer apply.
Yeah, but
the
H1B the thing is, there may be a situation where even doing change of status is not dangerous. Okay, so just make sure that your lawyers look at your whole case.
Sure, Rajivji.
Okay.
Thank you very much for your
You're welcome.
I appreciate it.
Good
and the other caller, you were suggesting him for Freedom of Information Act. That's a form 639 to get the
G639. Thank you for sharing that.
639.
Yeah.
All right. Thanks, Rajivji.
Thank you. Bye bye. Okay, the last call of the day, folks. Oh no, there's one more after that. Okay, well, we'll do one more. It's Escondido, California. Go ahead, please.
Yeah, hi Rajiv. This is Prashant. I have a question number 12. It's much similar to the Vishal. I'm on the same boat. So my question is that I have already resigned from L1 employer now. As per your suggestion also, like there is a 60 days of gray area which I can use and I can join on H1B on 1st of December. So what will happen to my L1, because that's my company is not yet ready to revoke that. My L1 is on the process. So how I can
hang on 1 second. Let me look at your case one more time.
Sure.
That I-94 expired extension is pending. H1B approved, change of status effective 1st October. Okay, so you shouldn't worry about the extension. Just send something in writing to the employer saying, please withdraw my L1, my L2 because I already have an H1. I'm joining this employer. Something like that you can say.
Okay. So my next question is that I have a emergency, already emergency. So I'm planning to visit India in sometime in December 2nd week. So my employer is telling me that it will start my payroll, even though there is he is still finding a job. But as per the rules, they run my payroll from 1st of December. So on just one payroll pay slip. So is it advisable to go in India and get the stamping done?
Look, getting H1 visa stamping has become very difficult, especially where you are working at a client site. Okay. Now, I'm not concerned about 1 or 2 or 3 pay stubs. I'm concerned about whether or not there is a genuine project there. If there's a genuine project, no pay stubs, 1 pay stub, 2 pay stubs. As long as it covers the entire period, legal period, you have no problem.
Okay. So how this 60 days will be covered? Means, is that questionable in future, because my L1 salary I'm getting now will be paid for the entire November month also. So
Well, let me.
November,
No, this salary you are getting because of work you have already performed, right?
Yes.
Wait, you're not supposed to continue working once your change of status is approved, okay? But you got to know about it later, so you might be okay. The point is, any employee can continue receiving salary from L1 source if it is based upon work already performed. So if you are getting paid in November for work that you did in October, that's fine.
Yeah, but right now I'm working for L1 and I'm getting
You are not supposed to.
For...
That's unauthorized employment.
So what I do with that is, should I ask employer to stop my salary? Because this is my basic consultant who just like last week only he told me like your H1 is approved and you have to resign immediately.
Yeah, this is a problem because here is my problem with this whole situation. Work with the L1 is unauthorized. It's illegal because you have been converted to H1B. I'm not sure I can spend so much time with you going over all the options, but you need to address this. This work cannot continue like this. Whatever you do now, you're breaking the law. So please get together with your lawyers or do a consultation with me or come back next conference call. I really don't have enough time today. I've already been going for about an hour and a half or more. So bottom line is, this is not an easy situation for me to analyze and answer. This is illegal employment. You shouldn't be working here anymore. Once you find out that your H1B is approved, change of status is approved, you should not be employed on L1B. That should be over right away. And there's no grace period here. Okay? I gotta go. I'm sorry. Listen, I really have. I have to go. Like I said, hour and a half I've been talking. Let me do the last call. If I have still some energy left, I'll talk to you. Sit tight, okay? Let me see how much is the last. Okay. Give me 1 second. Campbell, California, go ahead, please.
Rajivji, I asked you my question earlier.
Oh, you're done?
30 seconds, please.
Okay, you're done.
No, just one. I'm going to lose my job in maybe three weeks. That's almost sure.
Okay.
So you recommended that I should file a visitor visa.
Right.
What's the best time to file for the visitor visa?
See, because visitor visa can be filed online. Form I-539 can be filed online. You can do it even one day before your last pay period.
Okay.
Okay. So if your last pay period covers you till tomorrow, you could file the application today.
Okay.
All right.
So and it's a valid reason for me to say that I was terminated.
The truth and nothing but the truth. Read my blog entries on this. They tell you exactly what to do.
Okay.
All right.
Very fair. Thank you.
Good luck.
Okay. Thank you.
All right. Okay. I'll give you 5 more minutes, but then I'm really getting tired, guys. I've been talking nonstop for a long time. So what should you do? You're on L1. You found out your H1B change of status is approved. I can't tell you what you should do, but I can tell you what you cannot do. You cannot continue to work on L1. That's illegal. Okay. If you want to continue to work on L1, The only way you can do that is to go outside USA, get a new L1 visa and come back in. Because even working one day without authorization puts you out of status. Now, the fact that your H-1B employer concealed the approval or did not get the approval is not going to be much help. Okay? So, if you want to join the H-1B employer, beginning December 1st, can you do that? Yes, but can you continue to work on L1 while you are waiting to join the H-1B employer? No, because your change of status is approved. Can you be paid for work that you've already done? Yes, you can. This is a tricky situation.
But, yeah.
Guys, hang on. Let me make one thing clear. I'm not going to answer any more questions. Please don't raise hands. We are done here. I just saw somebody else raise their hand. I can't do any more questions. Okay. Real quickly, anything else I can help you with before I hang up?
Rajesh,
Yeah?
so when I'm starting from 1st December, so is that 30-60 days rule is applicable? Means we are finding a job and that's the reason we want to continue status on L1?
Hang on.
L1 is unenforceable.
The answer is it does not apply in these circumstances.
So is it questionable in the future?
Well, the good thing is, as long as you don't lie to the government anytime in the future, this type of unauthorized employment is not likely to come back and haunt you, as long as you keep it truthful. Okay, so it's not going to cause you any permanent damage. My advice would be to immediately stop working on the L1 and join the H-1B employer from December 1st. Okay.
Yes, that is what I'm going to do now. So
Okay.
the first December,
I really have to.
notice.
I'm sorry, I have to cut you off. I am really tired. We've got to go. You need to talk with the lawyers who did the H-1B, or set up a time with our office to do a one-on-one consultation if you want any more time. Today I can't do it. I'm tired. Okay.
Okay, thank you.
Guys, I'll see you again in 2 weeks. Good luck. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.